I'm Judge Carolyn Tornetta Carluccio, Chair of the Montgomery Bar Association Community Outreach Committee. Our courts are widely regarded as some of the best in the world, but not all of our laws make common sense. That's why we have lawyers and judges. As Americans, we all have rights, and lawyers are here to protect those rights. In this segment, James Hollinger from the law firm of Smith, Aker, Grossman Hollinger will help you understand what you need to know about wills.
Hello, today I'm going to talk about wills. Wills are one of the methods of passing property on at a person's death. Other methods would be joint with right of survivorship. In the case of husband and wife, that's known as a tenants by entirety. Other methods would be to have a beneficiary designation. A person would be selected to receive an insurance policy or other properties. There are TOD, that's transfer on death, and POD, which is payable on death, both possible registrations. There's also in trust for accounts. You need a will to take care of all the things that are in the individual name of a person. So you should plan to name an executor in a will. You should name guardians for children in a will. You should also think about other arrangements. What happens if you don't have a will? You have the intestate law in Pennsylvania, which determines what happens to your assets that are in your individual name. Your spouse would be entitled to $30,000 plus 1/2 of the assets, the other half going to the children. If a second marriage is involved, then there would only be 50% to the wife and 50% divided among the children. The Register of Wills would appoint an administrator for your estate. It would end up that the Commonwealth would be your heir if you had nobody as close as a child of a first cousin as an intestate heir. So it's good to consider these things. A guardian would have to be appointed for your children under age 18. And that would be done by the Orphans Court. How do you make a will in Pennsylvania? It's pretty simple. All you have to do is have a writing, have it signed in the end, and make a disposition of some assets. You can also have a will if you just name an executor, because the law presumes that your intestate law is your disposition of assets. Other things you want to do in the will would be to name a trustee for assets for minor children or elderly people who have no capacity or limited capacity. You would want to name guardians for your children. There are guardians for their estates or assets and also guardians for their persons. The guardian for the person would take care of their health needs, they determine where they live, that kind of thing. Are there other reasons for making a will? Well, you can give gifts to charity. You can make specific gifts of important items in your life, your stamp collection, your grandfather clock, your antique car. You can also set up trusts to protect your family. In addition, you can set up trusts for tax-saving reasons, for estate planning purposes. Another companion piece that you would normally have with a will would be a power of attorney, where you would name an agent to act for you during your lifetime if you became incapacitated or you weren't able to deal with things yourself. The agent would take your place, so to speak, in making all your business decisions, taking care of your income tax filing, and doing other things that you would have to be doing. There's many other possibilities that the person would have to handle.
On behalf of the Montgomery Bar Association's Community Outreach Committee, a group of lawyers and community leaders from Montgomery County, I'd like to thank today's presenters. Be sure to check back soon for more information on what you need to know about the laws that impact each one of us.